Hi, I'm Natalie, and yes, my own mother stood in front of my entire graduation party just to announce that my law degree was absolutely pathetic and that I'd never amount to anything more than a public defender scraping by on government scraps. She smiled while saying it, like watching me crumble was her favorite weekend entertainment. What she didn't know was that Justice Elena Rodriguez had already been watching my work for months, and 3 days later, my phone would ring with an offer that would silence not just my mother, but every person who ever bet against me. Stick around, because what happened next didn't just change my career, it rewrote everything my family thought they knew about success. Before we jump back in, tell us where you're tuning from, and if this story touches you, make sure you're subscribed, because tomorrow I've saved something extra special for you. Growing up in Lakewood, Colorado, I learned early that love in our house came with conditions, and I never seemed to meet them. My mother, Patricia, worked in commercial real estate, closing million-dollar deals while wearing power suits that cost more than most people's monthly rent. She had this way of walking into rooms like she owned them, her heels clicking against marble floors with the confidence of someone who'd never been told no. Everything about her screamed success, from her perfectly styled auburn hair to the way she could negotiate contracts that left grown men speechless. Then there was my sister Caroline, 2 years older and seemingly crafted from my mother's exact blueprint. Caroline had inherited Mom's sharp business sense and her ability to charm anyone within a 5-mile radius. While I spent weekends buried in books about constitutional law and civil rights cases, Caroline was networking at country club events and landing internships at prestigious marketing firms before she'd even finished her communications degree. She spoke fluent corporate, understood the language of profit margins and market positioning, and could turn any casual conversation into a potential business opportunity. Me? I was the anomaly. The daughter who chose books over business lunches, who got excited about Supreme Court decisions instead of stock portfolios, who believed that justice mattered more than profit margin. From the time I was 12 and announced I wanted to be a lawyer, my mother's disappointment settled over our house like a permanent fog. Not the kind of lawyer who made headlines for defending celebrities or negotiating corporate mergers, but the kind who actually cared about protecting people's rights and fighting for those who couldn't fight for themselves. The University of Colorado Law School acceptance letter arrived on a Tuesday morning in March. I remember because I'd been checking the mailbox obsessively for weeks, my stomach knotting every time I heard the mail truck rumble down our street. When I finally saw the thick envelope with the university's seal, my hands shook so badly I could barely tear it open. The word congratulations jumped off the page, and for exactly 30 seconds I felt pure, uncomplicated joy. I ran into the kitchen where my mother sat at the granite island, her laptop open to spreadsheets and her phone buzzing with what I'm sure were very important business calls. Caroline was there too, home from her marketing internship at a firm downtown, looking polished and professional in a way that seemed effortless. "I got in," I said, my voice breathless with excitement. "Law school. Full scholarship." My mother glanced up from her screen, her expression barely shifting. She took a sip of her coffee, a blend she had shipped in from some exclusive roaster in Seattle, and gave me the kind of look she usually reserved for particularly disappointing quarterly reports. "A scholarship," she repeated, her tone flat. "So they're paying you to attend because they feel sorry for you." The joy deflated so quickly I actually felt dizzy. "No, Mom. It's merit-based. They only give it to the top applicant." Caroline looked up from her phone where she'd been scrolling through what appeared to be campaign materials for some client. "Law school's a pretty big commitment, Nat. Are you sure you've thought this through? I mean, the legal market is completely oversaturated right now. Plus," my mother added, closing her laptop with a decisive snap, "most lawyers end up miserable and overworked. The successful ones work 100-hour weeks and have no personal lives. The unsuccessful ones," she shrugged, letting the implication hang in the air like smoke. I wanted to argue, to explain that this scholarship was incredibly competitive, that the acceptance rate was less than 15%, that I'd worked my entire undergraduate career toward this moment. Instead, I found myself nodding and mumbling something about how I'd think it over, even though I'd already put down my deposit that morning. That night, I called my Aunt Helen, my father's sister who lived in Boulder and taught high school English. Helen had always been different from the rest of my family, more interested in ideas than income, more concerned with doing good work than making good money. She listened while I told her about the scholarship and my mother's reaction, her silence stretching long enough that I started to wonder if the call had dropped. Your mother, she finally said, her voice careful, has a very specific definition of success. It doesn't make her definition right. But what if she's right about law school? What if I am just setting myself up for disappointment? Natalie, Helen said, and I could hear her moving around her kitchen, probably making tea the way she did when she needed to think. I've watched you since you were little. You've never wanted anything the way you want this. That has to count for something. Law school turned out to be simultaneously the most challenging and most exhilarating experience of my life. The University of Colorado's campus in Boulder felt like stepping into a different world, where constitutional law wasn't an abstract concept but a living, breathing framework that shaped every aspect of American life. My professors challenged us to think beyond black-letter law, to understand the social and political context that shaped legal decisions, to see ourselves as future guardians of justice rather than just future earners of legal fees. Professor David Chen taught constitutional law with the passion of someone who genuinely believed that understanding the law could make the world a better place. He was young for a tenured professor, maybe 40, with kind eyes behind wire-rimmed glasses and a habit of pacing while he lectured that made every class feel like a conversation rather than a performance. During my second semester, he pulled me aside after class. "Have you considered constitutional litigation?" he asked, gathering his papers with the careful attention of someone who respected books and learning. "Your analysis of the 14th Amendment cases shows real insight." I felt a flutter of pride mixed with uncertainty. "I've thought about it, but civil rights law doesn't exactly pay well." Professor Chen smiled, the kind of smile that suggested he'd heard this concern many times before. "Natalie, there are different kinds of wealth. Some people get rich from their work. Others get rich by doing work that matters. Both are valid choices, but you need to decide which kind of rich you want to be." That conversation stayed with me through my second and third years, especially as the pressure from home intensified. Every phone call with my mother included subtle and not-so-subtle suggestions that I should be looking at corporate law firms, that I should be networking with the kind of people who could offer me real opportunity, that I was wasting my intelligence on idealistic pursuits that would never pay the bills. Caroline, meanwhile, had landed a position at a prestigious marketing firm in Denver and was already making more money than I expected to earn in my first 5 years out of law school. She'd bought a sleek downtown condo and drove a car that cost more than my entire undergraduate education. During family dinners, the conversation inevitably turned to her latest campaigns, her growing client list, her rapid advancement within the firm. Caroline closed the Morrison account, my mother announced during one particularly tense Sunday dinner, 6 figures. At 20, I pushed food around my plate, trying to calculate how many hours I'd need to work at the legal aid clinic where I volunteered to earn what Caroline made in a single contract. The math was depressing. "That's amazing," I said, and I meant it. Caroline worked hard and deserved her success, but I couldn't shake the feeling that these conversations were less about celebrating Caroline and more about highlighting my own poor choices. "What about you, Natalie?" my mother asked, her tone suggesting she already knew she wouldn't like the answer. "Any job prospects? Real jobs, I mean." I'd been offered positions at 2 mid-sized firms in Denver, both doing insurance defense work that would pay well but felt like slowly drowning in paperwork. I'd also been accepted into a fellowship program that would place me with a civil rights organization in Washington, working on cases that actually mattered but paid barely enough to cover rent in one of the most expensive cities in the country. "I'm still weighing my options," I said. My mother's sigh was audible from across the table. "Natalie, at some point, you need to be practical. This fantasy about changing the world through law is sweet, but you have student loans to pay and a life to build. Caroline understands that success requires sacrifice." After dinner, I helped clear the table while Caroline and my mother discussed some business opportunity Caroline was considering. Their conversation flowed effortlessly between market analysis and strategic planning, a language I understood intellectually but had never learned to speak fluently. I felt like a translator listening to my native tongue, recognizing the words but missing the cultural context that made them meaningful. That night, I sat in my childhood bedroom, surrounded by boxes of law school notes and case studies, and tried to imagine myself in 5 years. The corporate law track would mean a nice apartment, a reliable car, the ability to pay my student loans without constantly checking my bank balance. It would mean my mother's approval, family dinners where I had accomplishments to share that actually impressed people. But it would also mean spending my days defending insurance companies against claims from people who'd lost everything, or helping corporations find loopholes to avoid paying taxes, or drafting contracts designed to protect the wealthy from the consequences of their decisions. The work would be intellectually challenging and financially rewarding, but it wouldn't be the kind of work that let me sleep peacefully at night. The fellowship in D.C. represented everything I'd dreamed about since that first constitutional law class. Real cases affecting real people, the chance to work on issues that could set precedents and change lives, mentorship from attorneys who dedicated their careers to public service. It would also mean years of financial struggle, shared apartments with roommates, and the constant stress of wondering if I was smart enough or tough enough to succeed in an environment where the stakes were always high and the resources were always limited. I pulled out my laptop and started researching the civil rights organization that had offered me the fellowship. The National Justice Initiative had been founded in the 1960s and had played crucial roles in landmark civil rights cases for decades. Their current docket included voting rights challenges, immigration advocacy, and criminal justice reform. The attorneys profiled on their website looked tired but fulfilled, like people who went to bed each night knowing their work mattered. One name caught my attention: Justice Elena Rodriguez. Before her appointment to the Supreme Court 3 years earlier, she'd spent 2 decades as a civil rights attorney, including 5 years with the National Justice Initiative. Her biography mentioned groundbreaking work on educational equity and immigrant rights, cases that had literally changed the legal landscape for millions of Americans. I clicked through to recent Supreme Court decisions, where Justice Rodriguez had written majority or dissenting opinion. Her writing was elegant and precise, cutting through legal complexity to reveal the human stakes underlying every case. In a recent dissent on a voting rights case, she'd written, "The Constitution is not a museum piece to be admired from a distance, but a living document that must evolve to protect the rights of each generation. Our duty is not to preserve the status quo, but to ensure that justice remains accessible to all Americans, regardless of their economic circumstances or political power." Reading those words felt like finding water in a desert. This was the kind of legal thinking that had drawn me to law school in the first place. The belief that legal advocacy could be a tool for creating a more just society rather than just a method for accumulating wealth. I closed my laptop and made my decision. The next morning, I would accept the fellowship and move to Washington, D.C. I would disappoint my mother and worry my bank account, but I would be doing work that aligned with my values and my vision for what law could accomplish. The graduation party took place 3 weeks later in my parents' backyard, under a white tent that my mother had rented from the same company that catered her business event. The guest list included extended family, friends, and several of my mother's business associates who I suspected had been invited primarily to witness Caroline's latest achievements rather than celebrate my graduation. I wore a simple black dress that I'd bought specifically for job interviews, conservative and professional but not particularly memorable. Caroline looked stunning in a designer dress that probably cost more than my entire interview wardrobe, her makeup flawless and her hair styled in a way that suggested she'd spent considerable time and money at a salon that morning. The party followed a predictable pattern. Guests arrived, admired my parents' perfectly landscaped garden, and made polite conversation about the weather and local real estate market. Several people congratulated me on graduating law school, though their questions revealed that most of them weren't entirely sure what kind of law I planned to practice. "So you'll be joining a firm in Denver?" asked Mrs. Peterson, one of my mother's longtime clients. "Actually, I'm moving to Washington, D.C. for a fellowship with a civil rights organization." Mrs. Peterson's smile faltered slightly. "Oh, how interesting." These conversations happened repeatedly throughout the afternoon, each one following the same basic script. Initial enthusiasm for my law degree, followed by confusion or polite disappointment when I explained my actual career plans. I started to feel like I was disappointing people I'd never even met, failing to live up to expectations I didn't know existed. The worst part was watching Caroline work the room with effortless charm, discussing her latest marketing campaigns and networking with my mother's business contacts like she'd been doing it her entire life. She had a natural talent for making every conversation feel important, for making each person feel like their concerns and interests mattered to her personally. I was standing near the dessert table trying to look busy while eating cake. I didn't really want when my mother called for attention. She stood near the center of the tent, wine glass in hand, looking elegant and confident in a way that commanded immediate respect. "I want to thank everyone for coming to celebrate our girls," she began, her voice carrying easily across the gathered crowd. "Caroline, as many of you know, has had an absolutely remarkable year. She's exceeded every goal her firm set for her, brought in more new business than any first-year associate in the company's history, and she's just been promoted to account director." The applause was enthusiastic and genuine. Caroline beamed, accepting congratulations with grace and humility that somehow made her accomplishment seem even more impressive. "And Natalie," my mother continued, her tone shifting in a way that made my stomach clench, "has just graduated from law school." More polite applause, though notably less enthusiastic than Caroline's reception. "Now I know some of you have been asking about Natalie's career plans," my mother said, her smile never wavering but her words carrying a weight that felt deliberately cruel. "And I have to say I'm concerned." The tent grew quiet in the way that spaces do when people sense conflict approaching but aren't sure whether to stay or leave. "Natalie has decided to pursue public interest law," my mother continued, pronouncing the words like they tasted unpleasant, "which means she'll be working for essentially no money, on cases that don't matter to anyone important, trying to help people who probably can't be helped anyway." I felt my face burning, a combination of embarrassment and anger that made it hard to breathe properly. Every person in that tent was staring at me, their expressions ranging from sympathy to secondhand embarrassment to outright confusion. "But I suppose someone has to do those jobs," my mother concluded with a shrug that suggested she couldn't imagine why anyone would voluntarily choose such a path. Even if they are absolutely pathetic, the silence that followed was crushing. I stood there, cake plate in hand, feeling like I was drowning in front of 50 people who had just witnessed my mother publicly humiliate me at what should have been my celebration. No one spoke, no one moved, no one even seemed to be breathing. Finally, Aunt Helen stepped forward, her voice cutting through the silence like a knife. "Patricia," she said, her tone sharp enough to make my mother's confident expression falter slightly. "That was completely inappropriate." But the damage was done. The party continued, but the energy had shifted. People spoke in quieter voices, avoided eye contact with me, and began making excuses to leave earlier than they probably would have otherwise. I spent the rest of the afternoon feeling like a failure, like someone who had disappointed not just her mother but everyone who had ever believed in her potential. That night, after the tent had been disassembled and the last guests had driven away, I sat in my car in my parents' driveway and cried harder than I had since the day my childhood dog died. Not just because of my mother's words, but because part of me wondered if she might be right. Maybe I was making a terrible mistake. Maybe choosing principle over profit was just another way of choosing failure over success. But then I thought about Justice Rodriguez's dissent, about Professor Chen's question about different kinds of wealth, about all the cases I'd studied where attorneys had risked everything to defend people who couldn't defend themselves. I thought about the lawyers who had fought for civil rights in the 1960s, who had challenged unjust laws even when doing so meant sacrificing their own comfort and security. My phone buzzed with a text from Rachel Kim, my law school study partner who had also accepted a fellowship with a different public interest organization. "How was the party?" she asked. I stared at the message for a long time before responding. "Complicated," I typed back, "but I'm still moving to DC." "Good," she replied immediately. "The world needs more lawyers who care about justice than lawyers who care about money." 3 days later, I was packing my belongings into a rental truck when my phone rang. The number had a D.C. area code, but I didn't recognize it. "Is this Natalie Brooks?" asked a voice I didn't immediately recognize. "Yes, this is Natalie. This is Justice Elena Rodriguez's chambers. The justice would like to speak with you. Can you hold for a moment?" I nearly dropped the phone. My hands trembled as I held the phone, certain that this had to be some kind of mistake or elaborate prank. Justice Elena Rodriguez wanted to speak with me. The same Justice Rodriguez whose opinions I'd been studying for years, whose legal reasoning had shaped my understanding of constitutional law. "Miss Brooks?" came a warm, slightly accented voice that I recognized immediately from court recordings I'd watched dozens of times. "This is Justice Rodriguez. I hope I'm not calling at an inconvenient time." I looked around at the chaos of my packing, boxes scattered across my childhood bedroom, my law school diploma still in its frame on my desk. "No, not at all, Justice Rodriguez. I'm honored that you're calling. I've been following your work," she said, and I could hear papers rustling in the background. "Professor Chen shared your law review article on voting rights enforcement with my chambers. Your analysis of the intersection between the 14th and 15th Amendments was quite impressive." I felt dizzy. The article she was referencing had taken me 6 months to research and write, exploring how modern voting restrictions disproportionately affected communities of color in ways that violated both constitutional amendments. It had been published in the university's law review, but I never imagined anyone beyond academia would read it, let alone a Supreme Court justice. "Thank you, Justice Rodriguez. That means more to me than you could possibly know. I understand you've accepted a fellowship with the National Justice Initiative," she continued. "They do excellent work. I spent some of my most formative years there, learning how law can be a tool for social change rather than just social control." "Yes, ma'am. I start next month." There was a pause, and I heard what sounded like a coffee cup being set down on a desk. "Miss Brooks, I'm calling because I have a proposition for you. How would you feel about postponing that fellowship for a year to work directly with my chambers?" The words hit me like a physical force. I actually had to sit down on my unmade bed, surrounded by half-packed boxes, and the detritus of my law school years. "I'm sorry, could you repeat that?" Preparing and narrating this story took us a lot of time, so if you are enjoying it, subscribe to our channel. It means a lot to us. Now back to the story. Justice Rodriguez laughed, a sound that was both professional and genuinely warm. "I'm offering you a position as my personal research attorney. It's a 1-year appointment, renewable based on performance and mutual interest. You'd be working on some of the most significant constitutional cases of our generation, conducting research that directly influences Supreme Court decisions." I tried to process what she was saying, but my brain seemed to have short-circuited. Working directly for a Supreme Court justice was the kind of opportunity that most lawyers could only dream about. It was the kind of position that opened doors throughout the legal profession, that carried prestige and influence far beyond anything I could achieve at a civil rights organization. "The position comes with a substantial salary," Justice Rodriguez continued, "significantly more than the fellowship would pay. You'd be based here in Washington, working directly out of the Supreme Court building. It's demanding work, but I believe you have the intellectual rigor and moral clarity to excel in this environment." "Justice Rodriguez, I'm incredibly honored, but I have to ask why you're offering this to me. I mean, there must be hundreds of qualified candidates." "There are," she agreed, "but most of them see Supreme Court clerkships as stepping stones to lucrative careers in corporate law. I need someone who understands that constitutional law isn't an academic exercise, but a living framework that affects real people's lives. Your writing demonstrates that understanding." I thought about my mother's words at the graduation party, about choosing a pathetic career path that would never amount to anything significant. Here was Justice Rodriguez, one of the most powerful legal minds in the country, offering me an opportunity that would instantly transform my professional prospects. "When would you need an answer?" I asked. "Take your time," she said. "This is a significant decision, but I'd need to know within the week so I can make alternative arrangements if necessary." After we hung up, I sat in the silence of my bedroom for what felt like hours. The fellowship with the National Justice Initiative had been my dream job, the perfect entry point into civil rights law. But this opportunity with Justice Rodriguez was something beyond dreams, the kind of position that could define an entire career. I called Professor Chen first, partly because I trusted his judgment, and partly because I needed to hear from someone who understood the legal profession from the inside. "Natalie," he said after I'd explained the situation, "this is extraordinary. Working directly with Justice Rodriguez would give you insights into constitutional law that you simply can't get anywhere else. But what about my commitment to the National Justice Initiative? What about public interest law? Who says you have to choose permanently?" Professor Chen asked. "1 year with Justice Rodriguez could make you a more effective advocate for the rest of your career. You'd understand how the Supreme Court actually works, how decisions get made, what kinds of arguments are most persuasive at the highest level." That evening, I drove to Boulder to have dinner with Aunt Helen. Her small house near the university felt like a sanctuary, filled with books and plants, and the kind of comfortable clutter that suggested someone who valued ideas over appearance. "Tell me what you're really worried about," Helen said as we sat on her back porch, watching the sun set behind the mountains. "I'm worried that I'm making decisions based on other people's expectations instead of my own values," I admitted. "My mother thinks public interest law is pathetic. Now I have this incredible opportunity that would prove her wrong, but I'm not sure if I want it for the right reasons." Helen poured herself more tea, taking her time to think before responding. "What do you think Justice Rodriguez sees in you?" "I don't know. Maybe she thinks I'm smart." "Natalie, there are thousands of smart law students. What makes you different?" I thought about my law review article, about the months I'd spent researching voting rights cases, interviewing community organizers and civil rights attorneys who had been fighting these battles for decades. "I think she sees that I care about the people affected by these legal decisions, not just the intellectual puzzle of constitutional interpretation. Then maybe the question isn't whether you should take this job, but how you can use this job to serve the people you care about." That night, I called the National Justice Initiative and spoke with the director of their fellowship program. I explained the situation with Justice Rodriguez and asked if they would consider deferring my fellowship for a year. "Are you kidding?" She laughed. "Natalie, working with Justice Rodriguez would make you infinitely more valuable to our organization. We'd be thrilled to hold your position." 2 days later, I called Justice Rodriguez's chambers and accepted the position. Her assistant scheduled me to start the following Monday, which gave me exactly 4 days to find an apartment in Washington, D.C., and completely reorganize my life. The conversation with my parents was everything I expected, and nothing I was prepared for. I drove to their house on Saturday morning, finding my mother in her home office, reviewing contracts, and my father reading the newspaper in the living room. "I have some news," I said, settling into the chair across from my mother's desk. "Please tell me you've come to your senses about this civil rights nonsense," my mother said without looking up from her computer. "Actually, I've been offered a position with Supreme Court Justice Elena Rodriguez. I'll be working as her personal research attorney." My mother's fingers stopped moving across her keyboard. She looked up slowly, her expression cycling through confusion, surprise, and something that might have been pride. "The Supreme Court?" she asked. "Yes. Justice Rodriguez called me personally. She's been following my work." My father appeared in the doorway, clearly having overheard our conversation. "Natalie, that's incredible. Supreme Court positions are incredibly prestigious. How much does it pay?" my mother asked. Ever practical. I named a figure that was more than double what the fellowship would have offered, more than Caroline made in her first year at the marketing firm. My mother leaned back in her chair, reassessing me, in a way that felt both gratifying and unsettling. "Well," she said finally, "that changes things considerably." The conversation continued for another hour, with my parents asking detailed questions about the position, the responsibilities, the career opportunities it would create. For the first time in years, I felt like they were genuinely interested in my professional choices, rather than disappointed by them. But underneath their enthusiasm, I sensed something that made me uncomfortable. They were proud of the prestige and the salary, but I wasn't sure they understood or cared about the actual work I'd be doing. Justice Rodriguez had offered me this position, because of my commitment to civil rights law, but my parents seemed to interpret it as validation that I was finally pursuing real legal work. That afternoon, Caroline came over to congratulate me. She seemed genuinely excited about my opportunity, but her questions revealed the same focus on status and earning potential that had characterized my parents' response. "This is going to open so many doors for you," she said as we sat by the pool behind our parents' house. "Supreme Court experience could get you hired at any firm in the country." "That's not really why I'm taking it," I said. "I know, but still, you'll have options you wouldn't have had otherwise." I spent Sunday packing again, this time for the move to Washington rather than the fellowship in. The irony wasn't lost on me that I was still moving to the same city, still pursuing public interest law, but now my family's attitude had completely shifted because of the prestige associated with my employer. Rachel called that evening to congratulate me on the Supreme Court position. "I'm not going to lie," she said. "I'm incredibly jealous, but also really excited for you. Justice Rodriguez is amazing. Have you met her?" Once at a conference, she spoke about the role of law in protecting vulnerable communities. It was inspiring. She's exactly the kind of person you want influencing Supreme Court decisions. Monday morning arrived gray and drizzly, typical Washington weather that matched my nervous energy. I took the metro to Union Station and walked the few blocks to the Supreme Court building, stopping on the steps to look up at the imposing marble facade. The words "Equal Justice Under Law" were carved above the entrance, a reminder of the ideals that had drawn me to law school in the first place. Security was extensive, involving multiple ID checks and metal detectors, before I was finally escorted to Justice Rodriguez's chambers on the second floor. The office was larger than I'd expected but not ostentatious, with floor-to-ceiling bookshelves, a large mahogany desk and windows that looked out over the Capitol building. Justice Rodriguez stood to greet me, extending her hand with a warm smile. She was smaller than she appeared in photographs, but commanded the room with a presence that was both authoritative and approachable. Her dark hair was pulled back in a simple bun, and she wore a navy blue suit that looked professional without being flashy. "Welcome to the Supreme Court, Miss Brooks," she said. "I hope you're ready to work." She introduced me to her small staff, 2 law clerks who had graduated from Harvard and Yale respectively, a secretary who had worked for the court for over 20 years, and another research attorney who was finishing his second year in the position. "Your primary responsibility," Justice Rodriguez explained as we settled in her office, "will be researching constitutional issues related to civil rights and voting rights cases. The court has several significant cases on this term's docket, and I want to ensure our decisions are grounded in both legal precedent and practical understanding of how they'll affect real communities." She handed me a thick folder containing case briefs, legal memos, and research requests. "Your first assignment involves a case from Arizona regarding polling place accessibility. The petitioners claim that requiring photo ID and proof of residency creates an undue burden on elderly and disabled voters. I need you to research the historical context of voting rights, protections, and analyze how similar requirements have been implemented in other states." I spent the rest of that first day immersed in research, reading case law and academic articles about voting rights enforcement. The work was intellectually demanding but exactly the kind of legal analysis I had hoped to do. Every case had real implications for real people, not just abstract constitutional principles. By the end of my first week, I had fallen into a routine that felt both challenging and deeply satisfying. I arrived at the court by 7 each morning, spent my days researching complex constitutional questions, and often didn't leave until well after 6 in the evening. The work was intense, but it was also meaningful in a way that made the long hours feel worthwhile. Justice Rodriguez proved to be an exceptional mentor, someone who pushed me to think more deeply about legal questions, while also helping me understand the practical implications of Supreme Court decisions. During our weekly meetings, she would ask probing questions about my research, challenge my assumptions, and share insights from her decades of experience in constitutional law. "Remember," she told me during one of these sessions, "we're not just interpreting law here. We're shaping the legal framework that will govern this country for generations. Every opinion we write becomes precedent that future courts will follow. The weight of that responsibility was both thrilling and terrifying. I was contributing to decisions that would affect millions of Americans, helping to shape the legal landscape in ways that could protect civil rights or undermine them depending on how carefully we did our work. 3 weeks into the job, I was working late on a research memo when my phone rang. It was Caroline, calling from what sounded like a restaurant or bar. "Hey, how's life at the Supreme Court?" she asked, her voice slightly elevated over background noise. "Busy but incredible," I said, saving my work and leaning back in my chair. "Mom's been bragging about you to everyone," Caroline said. "I think she's told every client she has about your new job." I felt a complex mix of satisfaction and discomfort. After years of disappointment and criticism, it was gratifying to finally have my mother's approval. But I also knew that her pride was based more on the prestige of my position than on the actual work I was doing. "That's nice," I said non-committally. "She wants to throw you a celebration party when you come home for Thanksgiving. Invite all the people who were at your graduation party so they can see how well you're doing." The irony was striking. 4 months earlier, my mother had humiliated me in front of these same people by calling my career choice pathetic. Now she wanted to parade my success in front of them, not because she had gained new respect for civil rights law, but because working for the Supreme Court carried social status she could appreciate. "I'll think about it," I said. "Come on, Nat. You've earned the right to gloat a little." But gloating wasn't what I wanted. I wanted my family to understand and respect the work I was doing, not just the prestige associated with where I was doing it. I wanted them to appreciate that civil rights law mattered, that protecting voting rights and fighting discrimination were worthy pursuits regardless of who employed me to do them. That night, I called Aunt Helen and told her about Caroline's suggestion for a celebration party. "How do you feel about that?" Helen asked. "Confused," I admitted. "I'm glad my family is proud of me, but I'm not sure they're proud for the right reasons." "Maybe the reasons don't matter as much as the result," Helen suggested. "If your success changes how they think about public interest law, isn't that a good thing?" I wasn't sure. Part of me wanted my family's unconditional support, their belief in my choices, even when those choices didn't align with their definition of success. But another part of me was simply grateful to finally have their approval, regardless of what had motivated it. The following month brought one of the most significant cases of my young career. The court agreed to hear arguments in a case involving gerrymandering, where a state legislature had redrawn congressional districts in ways that clearly diminished the voting power of minority communities. Justice Rodriguez assigned me to lead the research on this case, working with constitutional scholars and civil rights organizations to understand both the legal precedents and the practical impact of various redistricting schemes. The work was fascinating and complex, requiring me to analyze decades of voting rights cases, while also studying demographic data and electoral maps. I interviewed political scientists who had studied gerrymandering, civil rights attorneys who had challenged similar redistricting plans, and community organizers who had witnessed firsthand how gerrymandering affected political representation in their neighborhood. One evening, as I was working late in the law library, Justice Rodriguez stopped by my desk. "How's the gerrymandering research progressing?" she asked. "It's complicated," I said, gesturing to the stacks of books and printouts surrounding my workspace. "The legal precedents are clear about intentional racial discrimination, but proving intent is incredibly difficult when legislators can claim they were motivated by partisan rather than racial considerations." Justice Rodriguez nodded. "That's exactly the challenge we're facing. The question is whether we can develop legal standards that protect voting rights without getting the court overly involved in political questions." We talked for another hour about the case, discussing various legal theories and potential approaches to the constitutional questions involved. Justice Rodriguez challenged my thinking, asked probing questions about my research methodology, and shared insights from similar cases she had worked on during her years in private practice. "This is why I wanted you for this position," she said as our conversation wound down. You understand that constitutional law isn't just an intellectual exercise. These cases affect real communities, real people who depend on the courts to protect their fundamental rights. As winter approached, I had settled into a routine that felt both demanding and deeply fulfilling. My days were spent researching complex constitutional questions, my evenings often extended by reading and analysis that helped inform Justice Rodriguez's decision-making process. The work was challenging in ways I had never experienced, requiring me to think about legal questions from multiple perspectives, while considering the broader social and political implications of various judicial approaches. My relationship with my family had evolved in ways that were both gratifying and complicated. My parents called more frequently, asked detailed questions about my work, and seemed genuinely interested in my professional development. Caroline had started referring to me as my sister, the Supreme Court attorney, when introducing me to her friends, a description that carried obvious pride, but also reduced my complex work to a simple status marker. The transformation in my mother's attitude was perhaps the most dramatic. The woman who had publicly humiliated me at my graduation party now bragged about my accomplishments to anyone who would listen. She had started following Supreme Court news more closely, reading articles about cases I was working on and calling to discuss legal developments she had never previously cared about. But underneath this newfound approval, I sensed that her fundamental perspective hadn't really changed. She was proud of my success because it fit her definition of achievement: prestigious employment, substantial salary, social status that reflected well on our family. I wasn't convinced she had developed any deeper appreciation for civil rights law or public interest advocacy. This tension came to a head during a phone conversation in late November, when my mother called to finalize plans for the celebration party she wanted to throw during my Thanksgiving visit. "I've invited everyone who was at your graduation party," she said, her excitement palpable even over the phone, "plus some additional people who I think would be impressed to meet a Supreme Court attorney." "Mom," I said carefully, "I appreciate that you want to celebrate my job, but I hope you understand that I'm doing the same kind of work I plan to do at the civil rights organization. I'm just doing it from a different location." "Oh, Natalie," she laughed, "this is completely different. You're working at the Supreme Court, making real decisions that affect the entire country. That civil rights fellowship would have been small time, helping people with problems that don't really matter in the grand scheme of things." Her words hit me like a physical blow. She still didn't understand. She still thought that civil rights law was only valuable when it was conducted from a prestigious institution, that fighting for voting rights only mattered when it was done at the Supreme Court level. "The problems civil rights organizations work on do matter," I said, my voice tighter than I intended. "They matter to the people whose rights are being violated, whose voices are being silenced, whose communities are being ignored." "Of course, dear," my mother said in the tone she used when she thought I was being unnecessarily dramatic. "I'm just saying that what you're doing now has much more impact." That conversation stayed with me for days, troubling me in ways I couldn't quite articulate. I was grateful for my family's support, but I wanted them to respect my work for the right reason. I wanted them to understand that Justice Rodriguez had hired me, not because I had abandoned my commitment to civil rights law, but because I had demonstrated that commitment through my academic work and professional choices. 2 weeks before Thanksgiving, I made a decision that surprised even me. I called my mother and told her I appreciated her desire to throw a celebration party, but I preferred to keep my visit home low-key. "But Natalie," she protested, "this is your chance to show everyone how successful you've become." "I know," but success isn't about impressing other people. It's about doing work that matters, whether that work happens at the Supreme Court or at a small civil rights organization." There was a long pause before my mother responded. "I don't understand why you're being so difficult about this." "I'm not trying to be difficult. I just want you to be proud of me for the right reasons." "What do you mean?" "I want you to be proud because I'm fighting for justice, not because I have a prestigious job. I want you to understand that civil rights law matters, regardless of where it's practiced." Another pause, longer this time. "Natalie, I am proud of you. I'm proud that you're smart enough and talented enough to work at the Supreme Court, but are you proud of the work I'm actually doing? Of course, she said, but her tone suggested she wasn't entirely sure what that work entailed. When I hung up the phone, I felt both frustrated and oddly liberated. My family's approval had always been conditional, based on their definition of success rather than my own value. Working at the Supreme Court had earned me that approval, but it hadn't changed the fundamental dynamic between us. That realization was both disappointing and freeing. I no longer needed to win their respect for my career choices, because I had learned to respect those choices myself. Justice Rodriguez had offered me this position, not because I had abandoned my commitment to civil rights law, but because I had demonstrated the intellectual rigor and moral clarity to excel in this environment. The work itself continued to be deeply fulfilling. Each case presented new challenges, new opportunities to research complex constitutional questions and contribute to decisions that would shape American law for generations. I was learning from one of the most brilliant legal minds of our generation, while also having the opportunity to influence Supreme Court jurisprudence in ways that protected fundamental rights. As December approached and the court prepared for a series of major oral arguments, I realized that my mother's criticism at the graduation party had been wrong in more ways than she could possibly understand. My law degree wasn't pathetic, and my commitment to civil rights law wasn't a waste of my talents. I was exactly where I belonged, doing exactly the work I had always been meant to do. January brought the kind of intense cold that made Washington, D.C. feel like a different planet. But inside the Supreme Court building, the atmosphere was electric with anticipation. The court was scheduled to hear oral arguments in 3 major civil rights cases, including the gerrymandering case I had spent months researching. Justice Rodriguez had asked me to attend the arguments, not just as an observer but as part of her preparation team. The night before the gerrymandering arguments, I stayed at the court until nearly midnight, reviewing my research notes and preparing briefing materials that Justice Rodriguez would reference during the proceeding. The case involved congressional districts in North Carolina that had been redrawn in ways that clearly diluted the voting power of African American communities, but proving discriminatory intent remained the central legal challenge. The key question, Justice Rodriguez had explained during our preparation meeting, is whether we can establish legal standards that protect voting rights without creating a precedent that draws the courts too deeply into partisan political dispute. At 7 the next morning, I arrived at the court to find Justice Rodriguez already in her chambers, reviewing case files and making notes in the margins of legal briefs. She looked up when I knocked on her doorframe, gesturing for me to enter. "Ready for your first oral argument?" she asked. "I think so, though I'm more nervous than I expected to be," she smiled, the kind of expression that suggested she remembered her own first experiences in courtrooms, where history was made. "That nervousness means you understand the importance of what we're doing here. These arguments will shape voting rights law for decades." The courtroom itself was smaller than I had imagined, but carried a weight of authority that was almost palpable. I sat in the section reserved for court staff, watching as attorneys from both sides prepared their arguments, while journalists and legal observers filled the public gallery. The attorneys representing the North Carolina legislature looked confident, their legal team expensive and polished. The civil rights lawyers arguing for the petitioners appeared more modest, but carried themselves with the quiet determination of people who believed deeply in their cause. When the 9 justices entered and took their seats, the formal majesty of the Supreme Court became fully apparent. Justice Rodriguez, seated near the center of the bench, looked both authoritative and approachable, her presence commanding attention without seeming intimidating. The arguments themselves were fascinating and complex, with each side presenting sophisticated constitutional theories about the scope of federal oversight of state redistricting processes. The attorney representing the civil rights organizations argued that the North Carolina districts violated both the 14th and 15th Amendments by deliberately diluting minority voting power. The state's attorney countered that the redistricting was motivated by legitimate partisan considerations, rather than racial discrimination. Justice Rodriguez asked several probing questions during the arguments, challenging both sides to clarify their legal theories and address potential unintended consequences of various judicial approaches. Her questions revealed deep familiarity with voting rights precedents and practical understanding of how different legal standards would affect electoral processes nationwide. "Counselor," she said to the state's attorney, "you argue that partisan redistricting is beyond federal judicial review. But what happens when partisan redistricting achieves the same result as racial redistricting? Should the courts ignore the impact on minority communities simply because legislators claim partisan rather than racial motive?" The attorney's response was technically competent, but lacked the moral clarity that had characterized the civil rights lawyer's argument. Watching the exchange, I felt proud to work for someone who clearly understood that constitutional law should protect fundamental rights rather than provide cover for discriminatory practices. After the arguments concluded, Justice Rodriguez and I returned to her chambers to begin drafting preliminary notes for her eventual opinion. The process was intellectually demanding, requiring us to balance legal precedent with practical considerations, while also considering how our decision would interact with other areas of constitutional law. "What did you think of the argument?" Justice Rodriguez asked as we settled into her office. "I thought the civil rights attorney made a compelling case that the constitutional protections for voting rights should apply regardless of whether discrimination is motivated by race or partisan advantage. But we also need to consider how broadly we want federal courts to intervene in redistricting disputes. There's a real risk of creating precedents that drag the judiciary into political questions that might be better resolved through legislative processes." We spent the next several hours discussing various approaches to the legal questions raised by the case, analyzing how different outcomes would affect both voting rights protections and the appropriate role of federal courts in electoral disputes. Justice Rodriguez challenged my thinking, asked me to research additional precedents, and helped me understand the complex interplay between constitutional principles and practical governance considerations. That evening, I called Professor Chen to discuss the oral arguments and the legal questions they had raised. "How did Justice Rodriguez approach the constitutional issues?" "She's clearly concerned about protecting voting rights, but she's also thinking carefully about institutional questions regarding the court's proper role in electoral disputes." "That sounds like the kind of nuanced constitutional thinking that made her such an effective civil rights attorney before joining the court," Professor Chen observed. "She understands that good intentions aren't enough if they create precedents that ultimately undermine the legal protections you're trying to establish." 3 days later, my phone rang with a call from my mother. She had been following news coverage of the Supreme Court arguments and wanted to discuss my role in the proceedings. "I saw Justice Rodriguez mentioned in several newspaper articles about the voting rights case," she said. "Were you involved in preparing for those arguments?" "Yes, I've been researching the constitutional issues for several months." "That's wonderful, dear. I've been telling everyone that my daughter is helping to make Supreme Court decisions." Her pride was genuine, but something about her phrasing bothered me. She seemed more interested in my proximity to power than in the actual legal questions we were addressing. "The case is about protecting voting rights for minority communities," I said. "We're trying to ensure that redistricting can't be used to silence voices that deserve equal representation." "Of course," my mother said, though her tone suggested she wasn't particularly interested in the substantive issues. "The important thing is that you're working on cases that everyone considers significant." After we hung up, I realized that my mother's attitude encapsulated a broader challenge I was facing. Working at the Supreme Court had earned me respect and validation from family members and colleagues, but I sometimes wondered whether people were impressed by the institution rather than the work itself. This concern intensified the following week when Caroline called to tell me she had mentioned my Supreme Court position during a business meeting with potential clients. "It really helped establish credibility," she said. When I mentioned that my sister works for a Supreme Court justice, the whole tone of the meeting shifted. People took me more seriously. "I'm glad it helped your business," I said, though I felt uncomfortable about my job being used as a marketing tool. "You should leverage this position more," Caroline continued. "The connections you're making could be incredibly valuable for your future career." "I'm not really thinking about connections," I said. "I'm focused on doing good work on important cases." "Well, sure, but you should also be thinking strategically about what comes next. Supreme Court experience could get you hired at any law firm in the country." "Caroline, I'm not interested in corporate law," I know, but still, options are good to have. These conversations with family members highlighted a tension I hadn't fully anticipated. My work at the Supreme Court was deeply meaningful to me because it involved protecting constitutional rights and shaping legal precedents that would affect millions of Americans. But many people in my life seemed more impressed by the prestige of my employer than by the actual substance of my work. This disconnect became even more apparent during a dinner party at my Aunt Helen's house in February. Helen had invited several of her colleagues from the university, including professors of political science and history, who were genuinely interested in discussing Supreme Court jurisprudence and constitutional law. The conversation was stimulating and intellectually rigorous, covering topics ranging from the historical development of voting rights protections to contemporary debates about the proper scope of federal judicial power. These academics understood the significance of the cases I was working on and asked thoughtful questions about the legal and practical challenges involved in protecting constitutional rights. The tension between federalism and civil rights protection has defined American constitutional law for centuries, observed Dr. Martinez, a political science professor who specialized in judicial politics. It sounds like Justice Rodriguez is trying to find approaches that protect voting rights without creating precedents that inappropriately expand federal judicial power. Exactly. She's deeply committed to civil rights, but she also understands that poorly reasoned decisions can create backlash that ultimately undermines the protections we're trying to establish. That's the kind of sophisticated constitutional thinking we need more of on the court, added Dr. Williams, a historian who had written extensively about civil rights movements. Too many judges approach these cases with either pure activism or pure restraint, without considering how their decisions will interact with broader legal and political systems. The conversation continued for several hours, covering complex questions about constitutional interpretation, the role of historical context in legal decision-making, and the practical challenges of enforcing civil rights protections in diverse political environments. These academics appreciated the intellectual complexity of the work I was doing and understood its broader significance for American democracy. Driving home that evening, I reflected on the contrast between this dinner conversation and my recent discussions with family members. Helen's colleagues had been interested in the substance of my work, the constitutional principles at stake, and the broader implications of Supreme Court decisions for American society. My parents and Caroline, by contrast, seemed primarily impressed by the status and prestige associated with my position. This distinction mattered to me because it reflected different ways of understanding the value and purpose of legal work. The academics I had spoken with that evening appreciated that constitutional law could be a tool for social justice, a means of protecting fundamental rights and ensuring equal treatment under law. My family seemed to view my Supreme Court position primarily as evidence of professional success and social advancement. March brought another significant case to the court's docket, this one involving immigration law and the rights of undocumented children to public education. Justice Rodriguez assigned me to research the constitutional issues involved, working with advocacy organizations and legal scholars to understand both the legal precedents and the practical impact of various policy approaches. The case originated in Texas, where state lawmakers had passed legislation requiring school districts to verify the immigration status of students and deny enrollment to children who couldn't provide documentation of legal residence. Civil rights organizations had challenged the law as a violation of the Equal Protection Clause, arguing that children shouldn't be punished for their parents' immigration decisions. The legal research was fascinating but also emotionally challenging. I spent weeks reading case law about equal protection standards, while also reviewing reports about the educational and psychological impact of excluding undocumented children from public school. The human stakes were enormous, thousands of children who might be denied basic educational opportunities that could determine the trajectory of their entire lives. During one of our research meetings, Justice Rodriguez shared her own perspective on the constitutional questions involved. The Equal Protection Clause doesn't just protect citizens, she explained, it protects all persons within American jurisdiction. The question is whether denying education to undocumented children serves any legitimate governmental purpose that justifies the harm it causes. The state argues that limiting educational resources to legal residents is a reasonable way to control costs and discourage illegal immigration, I said. But do those arguments hold up under constitutional scrutiny? Justice Rodriguez asked, and what are the long-term consequences for American society if we create a permanent underclass of uneducated children who grow up in this country but are denied basic educational opportunity? The research process involved extensive collaboration with immigration attorneys, child advocates, and educational policy experts who helped me understand the broader context surrounding the legal question. I interviewed teachers who had worked with undocumented students, social workers who had seen the impact of educational exclusion on families, and policy researchers who had studied the economic and social effects of various immigration enforcement approaches. One conversation particularly stayed with me. I spoke with Maria Santos, a teacher in Houston who had worked with immigrant communities for over a decade. She described the devastating impact that educational exclusion policies had on children and families. These kids didn't choose to come here, she explained, but they're here and they're going to grow up in American communities. Denying them education doesn't make them disappear. It just ensures that they'll grow up without the skills and knowledge they need to contribute to society. What do you see as the strongest constitutional arguments for protecting their educational rights? I asked. Beyond the legal technicalities, there's a fundamental question about what kind of country we want to be, Maria said. The Constitution promises equal protection under law. That promise shouldn't depend on where someone was born or how they arrived here. This research deepened my understanding of how constitutional law intersected with real human law. The legal questions we were analyzing weren't abstract intellectual puzzles, but had direct consequences for thousands of children whose futures depended on how the Supreme Court interpreted the Equal Protection Clause. As I compiled my research findings into memoranda for Justice Rodriguez, I felt the weight of responsibility that came with working on cases that would shape constitutional law for generations. Every legal argument I researched, every precedent I analyzed, every policy implication I explored, could influence decisions that affected millions of Americans. The oral arguments for the education case took place in late March, with attorneys from both sides presenting sophisticated constitutional theories about the scope of equal protection guarantees and the state's authority to regulate access to public services. Justice Rodriguez again asked probing questions that revealed her deep understanding of both constitutional law and the practical implications of various legal approaches. During the arguments, I noticed several other justices seemed sympathetic to the state's position that immigration enforcement was primarily a federal responsibility and that states should have broad discretion to limit public services to legal residents. Justice Rodriguez and two of her colleagues appeared more concerned about the constitutional rights of children and the long-term social consequences of educational exclusion policy. After the arguments, Justice Rodriguez and I spent several days analyzing the legal questions and drafting preliminary notes for her eventual opinion. The process was intellectually demanding but also deeply satisfying, requiring us to balance competing constitutional principles while considering the broader implications of various judicial approaches. What's your sense of how the court will decide this case? I asked during one of our drafting sessions. It's difficult to predict, Justice Rodriguez said. There are legitimate constitutional arguments on both sides, and reasonable people can disagree about how to balance state authority with individual rights. But what about the children who will be affected by whatever decision we reach? That's exactly why we need to think so carefully about these questions, she said. Our decision will have real consequences for real people. We have a responsibility to get the constitutional analysis right, not just for the parties in this case, but for everyone who will be affected by the precedent we establish. In early April, I received an unexpected phone call from a reporter at the Washington Post who had been covering Supreme Court cases and wanted to interview me about my work with Justice Rodriguez. The reporter had apparently learned about my background and was interested in writing a feature story about young attorneys working on significant constitutional cases. I declined the interview, explaining that court staff generally didn't speak publicly about pending cases or internal deliberation. But the call made me realize that my work at the Supreme Court was gaining attention beyond legal circles, and that people were interested in the human stories behind major constitutional decisions. That evening, I called my mother to tell her about the interview request. Her reaction was enthusiastic and immediate. "You should have done the interview," she said. "That kind of publicity could be incredibly valuable for your career." "Mom, we don't talk to reporters about pending cases. It would be completely inappropriate." "But surely you could have discussed your background, your education, your general work responsibilities." The reporter was specifically interested in the cases I'm working on. "Talking to the media about Supreme Court business would violate professional ethics and probably cost me my job." My mother sighed in the way that suggested she thought I was being unnecessarily rigid about professional boundaries. "Sometimes you have to be strategic about these opportunities, Natalie. This isn't about strategy, it's about professional integrity." "Of course, dear," she said in a tone that indicated she didn't entirely understand my reasoning. This conversation reminded me again of the different ways my family and I understood the value and purpose of my work. They seemed to view my Supreme Court position primarily as a platform for professional advancement and public recognition. I saw it as an opportunity to contribute to constitutional law in ways that protected fundamental rights and promoted social justice. May brought the court's decision season, when justices would release their opinions in the major cases argued during the term. The anticipation was intense, both within the court building and among legal observers nationwide who understood the significance of the pending decision. Justice Rodriguez had been working on her opinion in the gerrymandering case for several weeks, crafting a decision that would protect voting rights while establishing clear legal standards for future redistricting disputes. I had contributed research and analysis that helped inform her constitutional reasoning, and I felt deeply invested in the outcome. When the gerrymandering decision was finally released, Justice Rodriguez had written a majority opinion that struck down the North Carolina redistricting plan while establishing a framework for analyzing similar cases in the future. The decision held that redistricting schemes that had the effect of diluting minority voting power violated the Constitution regardless of whether legislators claimed partisan rather than racial motivation. The opinion was both legally sophisticated and practically significant, providing clear guidance for lower courts while protecting constitutional voting rights. Legal scholars praised the decision as a landmark ruling that would strengthen democratic participation for decades to come. That afternoon, my phone rang with calls from family members who had seen news coverage of the Supreme Court decision. My mother was particularly excited, having read several newspaper articles that mentioned Justice Rodriguez's opinion as a significant constitutional ruling. "I saw your justice mentioned in the front page of the newspaper," she said. "This must be incredibly exciting for you." "It is," I said. "We've been working on this case for months, and I think the decision will really strengthen voting rights protection. Everyone's going to know that you contributed to a Supreme Court decision that's getting this much attention," my mother continued. "This kind of high-profile work will really enhance your reputation." I felt a familiar frustration with her focus on reputation and publicity rather than the substantive constitutional issues involved. "The important thing is that the decision protects voting rights for communities that have been historically disenfranchised." "Of course," she agreed, though her tone suggested she was more interested in the professional prestige than the civil rights implication. Caroline called later that evening with similar congratulations and similar emphasis on the career benefits of being associated with a high-profile Supreme Court decision. "Having your name associated with a landmark constitutional case will open doors throughout the legal profession." "Caroline, I'm not thinking about my resume. I'm thinking about the voting rights protections we established. I know you care about the constitutional issues," she said, "but you should also appreciate the career opportunities this creates." These conversations highlighted the ongoing tension between my family's understanding of professional success and my own values and priorities. They were proud of my achievements, but seemed to evaluate those achievements primarily in terms of status, prestige, and career advancement rather than the substantive impact of the work itself. Later that week, I had lunch with Rachel Kim, my law school friend who was completing her fellowship with a voting rights organization in Atlanta. Her perspective on the gerrymandering decision was markedly different from my family's reaction. "This decision is going to make our work so much easier," she said. "We've been challenging redistricting schemes for years, but proving discriminatory intent has always been incredibly difficult. Justice Rodriguez's opinion gives us legal tools we've never had before." That was exactly what she was trying to accomplish, I said. She wanted to create precedent that would actually protect voting rights in practice, not just in theory. "The civil rights community is buzzing about this decision," Rachel continued. "People understand that this ruling will strengthen democratic participation for generations." Our conversation continued for over an hour, covering the technical legal aspects of the decision and its practical implications for voting rights advocacy. Rachel appreciated the constitutional reasoning underlying Justice Rodriguez's opinion and understood how the decision would affect real communities and real electoral processes. This conversation reminded me why I had been drawn to civil rights law in the first place. Rachel and the advocates she worked with appreciated constitutional decisions, not for their prestige or publicity value, but for their impact on fundamental rights and democratic participation. They understood that good legal precedents could empower communities that had been historically marginalized and excluded from political processes. As my first year at the Supreme Court drew to a close, I reflected on the complex ways the experience had affected my relationship with my family and my understanding of my own professional goals. Working with Justice Rodriguez had been intellectually challenging and deeply meaningful, providing me with insights into constitutional law that would inform the rest of my career. But the experience had also highlighted the ongoing tension between my family's definition of success and my own values and priorities. They had embraced my Supreme Court position because it carried prestige and social status, but they still didn't seem to fully understand or appreciate the civil rights work that had made me attractive to Justice Rodriguez in the first place. In late May, Justice Rodriguez asked me to stay for a second year, extending my appointment and giving me the opportunity to work on additional constitutional cases. The offer was professionally exciting and personally gratifying, representing confidence in my abilities and potential for continued contribution to the court's work. When I called my parents to share the news about my contract extension, their reaction was enthusiastic and immediate. "Another year at the Supreme Court," my mother said. "This is wonderful news, Natalie. You're really establishing yourself as a significant legal talent." "The experience has been incredible," I said. "Justice Rodriguez is an amazing mentor, and the cases we're working on will shape constitutional law for decades. This kind of extended Supreme Court experience will make you incredibly marketable when you're ready to move to private practice," my father added. "Major law firms will be competing to hire someone with your background. I'm not planning to move to private practice," I said. "After my time here, I want to return to civil rights work." There was a pause before my mother responded. "Well, you'll have options. That's the important thing." As summer arrived and Washington settled into its typical pattern of humid heat and tourist crowds, I began working on new cases that would come before the court in the following term. The work continued to be challenging and meaningful, involving complex constitutional questions that would affect millions of Americans, but I also began thinking more seriously about my long-term career goals and the kind of legal work I wanted to pursue after my time at the Supreme Court concluded. My experience with Justice Rodriguez had deepened my understanding of constitutional law and enhanced my research and analytical skills in ways that would make me a more effective advocate, regardless of where I practiced. I knew that my family hoped this Supreme Court experience would lead me toward more prestigious and lucrative legal work, but I also knew that the experience had actually strengthened my commitment to civil rights law and public interest advocacy. Working on cases that protected fundamental rights and promoted social justice had been deeply fulfilling in ways that corporate law could never match. The question wasn't whether I would return to civil rights work, but how I could use my Supreme Court experience to become a more effective advocate for the communities and causes I cared about most. Justice Rodriguez had shown me that constitutional law could be a powerful tool for social change when practiced with both intellectual rigor and moral clarity. As I settled into my second year at the court, I felt confident that I was exactly where I belonged, doing exactly the work I had always been meant to do. My family's approval had been gratifying, but their approval wasn't what motivated me anymore. I was motivated by the opportunity to contribute to constitutional law in ways that protected fundamental rights and strengthened democratic institutions. The work itself was reward enough. September arrived with the kind of crisp autumn air that made Washington, D.C. feel like a city of possibilities. I had been working at the Supreme Court for over a year, and my second year brought new responsibilities and more complex constitutional challenges. Justice Rodriguez had begun involving me in strategic discussions about case selection and long-term jurisprudential approaches, treating me less like a research assistant and more like a trusted collaborator. The court's new term opened with several high-profile cases, but none more significant than Henderson v. State of Alabama, a challenge to a state law that effectively criminalized providing assistance to undocumented immigrants. The case had national implications, touching on questions of federal immigration authority, state police powers, and the constitutional limits of criminalizing humanitarian assistance. Justice Rodriguez assigned me to lead the constitutional research on this case, working with immigration scholars and civil rights organizations to understand both the legal precedents and the practical impact of various enforcement approaches. The work was complex and emotionally challenging, requiring me to analyze decades of immigration law while also considering the human consequences of different legal interpretations. During one of our research meetings, Justice Rodriguez shared her perspective on the constitutional questions involved. The tension here, she explained, is between legitimate state authority to assist with federal immigration enforcement and the constitutional limits on criminalizing basic human compassion. The state argues that preventing assistance to undocumented immigrants serves legitimate law enforcement purposes, I said, reviewing my notes. But at what point does immigration enforcement become so broad that it violates other constitutional principles? Justice Rodriguez asked, can states criminalize providing food, water, or medical care to people based solely on their immigration status? The research process was intensive and wide-ranging. I interviewed immigration attorneys who had defended people charged under similar laws, humanitarian aid workers who operated along the border, and constitutional scholars who had studied the intersection of immigration law and civil liberty. Each conversation deepened my understanding of the complex legal and moral questions at stake. One particularly impactful interview was with Dr. Sarah Martinez, a physician who had been prosecuted for providing medical care to undocumented immigrants in Arizona. Her case had been dropped after significant public pressure, but her experience illustrated the real-world impact of laws that criminalized humanitarian assistance. I took an oath to provide medical care to anyone who needed it, she explained during our phone conversation. These laws would make it a crime for me to honor that oath based on someone's immigration status. How do you think the constitutional questions should be resolved? I asked. The Constitution protects religious freedom, freedom of association, and basic human dignity. Laws that criminalize providing humanitarian assistance violate all of these principles. As I compiled my research into comprehensive memoranda for Justice Rodriguez, I became increasingly convinced that the Alabama law represented a dangerous expansion of state authority that threatened fundamental constitutional principles. The law didn't just assist with immigration enforcement, it effectively criminalized basic human compassion and created a system where people's constitutional rights depended on their immigration status. My growing expertise in immigration and civil rights law was beginning to attract attention beyond the Supreme Court. In October, I received an invitation to speak at a conference on constitutional law hosted by Georgetown University Law School. The organizers had learned about my work on voting rights and immigration cases and wanted me to participate in a panel discussion about the Supreme Court's approach to civil rights issues. I discussed the speaking invitation with Justice Rodriguez, who encouraged me to accept. Public engagement is an important part of constitutional scholarship, she said, Sharing your insights about Supreme Court jurisprudence helps educate the broader legal community about the court's reasoning and decision-making process. The Georgetown Conference was my first major speaking engagement, and I spent several weeks preparing my presentation on the constitutional principles underlying recent Supreme Court decisions in civil rights cases. My talk focused on the legal reasoning behind the gerrymandering decision and the broader implications for voting rights protection. The audience included law professors, practicing attorneys, law students, and legal journalists who asked sophisticated questions about constitutional interpretation and the court's institutional role in protecting civil rights. The discussion was intellectually stimulating and professionally rewarding, confirming my growing confidence in my ability to contribute meaningfully to constitutional scholarship. After my presentation, several attendees approached me with follow-up questions and professional opportunity. Professor Elizabeth Chen from Georgetown offered to collaborate on a law review article about voting rights enforcement. A civil rights attorney from the ACLU expressed interest in consulting with me on future Supreme Court briefs. A legal journalist asked whether I would consider writing commentary pieces about constitutional law for general audiences. That evening, I called my family to tell them about the conference and the positive reception my presentation had received. My mother's reaction was immediately enthusiastic. "A conference at Georgetown Law School," she said. "That's incredibly prestigious, Natalie." Who else was speaking? I mentioned several prominent constitutional scholars and federal judges who had participated in the conference. "You're really moving in impressive circles," my mother continued. "This kind of visibility will be excellent for your career advancement." The conference was about constitutional scholarship, not career advancement. I said, I was sharing insights about Supreme Court jurisprudence with the legal community. Of course, but the networking opportunities must have been incredible. Did you exchange business cards with the other speaker? Her focus on networking and career advancement, rather than the substantive constitutional issues discussed at the conference, reflected the ongoing tension in our relationship. She was proud of my professional achievements, but seemed to evaluate them primarily in terms of status and career prospects, rather than intellectual contribution or social impact. Caroline called later that evening with similar congratulations and similar emphasis on the career benefits of high-profile speaking engagements. "This is exactly the kind of visibility that top law firms look for," she said. "Partners at major firms probably saw coverage of the conference and made note of your participation." Caroline, "I'm not trying to impress law firm partners. I'm trying to contribute to constitutional scholarship." "I know, but you should also think strategically about how these opportunities position you for future career moves." November brought oral arguments in the Henderson immigration case, with attorneys from both sides presenting sophisticated constitutional theories about the scope of state authority and the limits of immigration enforcement. The arguments were particularly contentious, with several justices expressing sharp disagreements about the constitutional questions involved. Justice Rodriguez asked several penetrating questions during the arguments, challenging both sides to clarify their constitutional theories and address potential unintended consequences of various legal approaches. Her questions revealed deep familiarity with immigration law precedents and practical understanding of how different legal standards would affect both law enforcement and humanitarian organizations. "Counselor," she said to the attorney defending the Alabama law, "you argue that states have broad authority to assist with federal immigration enforcement, but does that authority extend to criminalizing constitutionally protected activities like religious exercise and freedom of association?" The attorney's response was technically competent, but failed to address the fundamental constitutional concerns raised by criminalizing humanitarian assistance. Watching the exchange, I felt confident that Justice Rodriguez understood both the legal complexities and the human stakes involved in the case. After the arguments concluded, Justice Rodriguez and I spent several intensive days analyzing the constitutional questions and drafting her opinion. The process was intellectually demanding but also deeply satisfying, requiring us to balance competing constitutional principles while considering the broader implications for both immigration law and civil liberty. This case presents a fundamental question about what kind of society we want to be. Justice Rodriguez said during one of our drafting sessions. Laws that criminalize basic human compassion undermine the constitutional values that define American democracy. The state argues that immigration enforcement requires strict measures that might limit some individual freedoms, I said. But at what cost, she replied. If immigration enforcement becomes so expansive that it criminalizes religious exercise, freedom of association, and basic humanitarian assistance, we've lost something essential about our constitutional system. While we worked on the immigration opinion, I continued to receive invitations for speaking engagements and professional opportunities. The American Bar Association asked me to present at their annual conference on civil rights law. A prominent law review invited me to write an article about Supreme Court decision-making processes. Several law schools expressed interest in having me visit as a guest lecturer. These opportunities were professionally exciting and intellectually rewarding, but they also intensified the pressure I felt from family members, who viewed them primarily as stepping stones to more prestigious and lucrative legal positions. Every professional achievement seemed to reinforce their expectation that I would eventually transition to corporate law or private practice. This pressure reached a turning point during Thanksgiving dinner at my parents' house. The conversation inevitably turned to my professional accomplishments and future career plans, with my mother and Caroline expressing increasingly direct opinions about the opportunities I should be pursuing. With your Supreme Court experience and all this speaking and writing, you could get hired at any major law firm in the country, my mother said over dessert. I'm not interested in corporate law, I said, a response I had given dozens of times. But Natalie, Caroline interjected, you could make partner at a top firm within a few years. The financial security would be incredible. I have financial security. I have meaningful work. I don't need to make partner at a corporate firm. My father, who had been mostly quiet during this conversation, finally spoke up. We just want you to maximize your potential, honey. You've worked so hard to get where you are. I am maximizing my potential, I said, my voice rising slightly. I'm doing exactly the work I've always wanted to do. Public interest law is fine as a stepping stone, my mother said, but at some point you need to think about your long-term financial future. Mom, Justice Rodriguez spent decades in public interest law before joining the Supreme Court. Civil rights attorneys have shaped American constitutional law for generations. This isn't a stepping stone to something better. This is the work I want to spend my career doing. The conversation continued in this vein for another hour, with my family expressing genuine concern about my financial future and professional prospects. While I tried to explain that I had already found the career I want, they seemed unable to understand that I valued the substance of my work more than the prestige or income associated with corporate law. That evening, I called Aunt Helen and told her about the dinner conversation, and my frustration with my family's continued pressure to pursue corporate opportunities. They love you, Helen said, but they're measuring your success by their own standards rather than yours. I know they mean well, but it's exhausting to constantly defend choices that make me happy and fulfilled. Maybe the question isn't whether they understand your choices, but whether you're confident enough in those choices to stop needing their validation. Helen's observation stayed with me for days. I realized that I had been seeking my family's approval for career decisions that I knew were right for me. Their validation would have been gratifying, but it wasn't necessary for me to pursue the work I found meaningful and important. December brought the court's decision in the Henderson immigration case, with Justice Rodriguez writing a majority opinion that struck down the Alabama law, while establishing clear constitutional limits on state immigration enforcement efforts. The decision held that states could assist with federal immigration enforcement, but could not criminalize constitutionally protected activities like religious exercise, freedom of association, and humanitarian assistance. The opinion was both legally sophisticated and morally compelling, providing practical guidance for law enforcement while protecting fundamental constitutional rights. Civil liberties organizations praised the decision as a landmark ruling that would protect both immigrants and citizens who provided humanitarian assistance. Legal scholars immediately recognized the broader significance of Justice Rodriguez's constitutional reason. The opinion didn't just resolve the immediate dispute about immigration enforcement, it established principles that would protect constitutional rights in other contexts where government authority might conflict with individual liberties. When the decision was announced, my phone rang immediately with calls from journalists, legal scholars, and civil rights organizations who wanted to discuss the constitutional implications. Several reporters asked specifically about my role in researching the case, though I declined to comment on internal court deliberations. The media attention was both exciting and overwhelming. National Public Radio invited me to participate in a discussion about Supreme Court immigration jurisprudence. The New York Times quoted legal experts who praised Justice Rodriguez's constitutional reasoning, noting that her opinion represented sophisticated thinking about the balance between government authority and individual rights. My family's reaction to the media coverage was predictably focused on the professional benefits of being associated with a high-profile Supreme Court decision. My mother called within hours of the decision's announcement, having seen news coverage that mentioned Justice Rodriguez's opinion as a significant constitutional ruling. "This is incredible publicity for you," she said. "Everyone's going to know that you contributed to a Supreme Court decision that's getting national attention. The important thing is that the decision protects constitutional rights," I said. "Of course, but the career benefits are also significant. This kind of high-profile work will make you incredibly attractive to top law firms." "Mom, I'm not trying to attract law firm attention. I'm trying to protect constitutional rights." "I understand that, dear, but you should also appreciate the opportunities this creates." Caroline's reaction was similar, emphasizing the career advantages of being associated with landmark constitutional decisions, rather than the substantive civil rights protections established by the court's ruling. "This decision is going to be studied in law schools for decades," she said. "Having your name connected to landmark Supreme Court cases will open every door in the legal profession. The decision matters because it protects vulnerable people, not because it opens career doors," I said. "Both things can be true," Caroline replied. "You can care about the constitutional issues and also benefit professionally from your involvement." These conversations reinforced my growing realization that my family would probably never fully understand or appreciate the work I was doing for its own sake. They were proud of my achievements, but evaluated them primarily through the lens of career advancement and social status, rather than intellectual contribution or social impact. In January, I received an unexpected phone call from Thomas Mitchell, a senior partner at Kellerman, Price & Associates, one of the most prestigious corporate law firms in Washington. He had apparently been following my work at the Supreme Court and wanted to discuss potential opportunities at his firm. "Miss Brooks," he said, "your Supreme Court experience and constitutional expertise would be incredibly valuable to our government relations practice. We represent major corporations in regulatory disputes that often involve constitutional questions." "I appreciate the interest," I said, "but I'm committed to my work at the Supreme Court and to civil rights law more generally." "Of course, but when you're ready to transition to private practice, we'd be very interested in discussing a position. We're talking about a substantial salary increase, partnership track, and the opportunity to work on cases that shape national policy. Thank you for thinking of me, but I'm not planning to transition to corporate law." "Well, if you change your mind, please give me a call. We're always looking for attorneys with your background and expertise." After hanging up, I realized that this call represented exactly the kind of opportunity my family had been encouraging me to pursue. Kellerman Price & Associates was the kind of prestigious firm that would satisfy all their criteria for professional success: substantial salary, social status, partnership potential, and high-profile clients. But the conversation had also confirmed my conviction that corporate law wasn't what I wanted to pursue. The firm was interested in my constitutional expertise, not because they shared my commitment to civil rights, but because that expertise could help their corporate clients navigate regulatory disputes. They wanted to use my knowledge of constitutional law to serve private interests, rather than public goods. That evening, I called Professor Chen and told him about the law firm's recruitment offer. "How did you respond?" he asked. I told them I wasn't interested in corporate law. "Good for you. Though I imagine your family had a different reaction. I haven't told them about the offer," I said. They're already pressuring me to consider corporate opportunities. I don't need to give them more ammunition. Natalie, you've found work that aligns with your values and utilizes your talents. That's rarer and more valuable than most people realize. Professor Chen's affirmation was helpful, but I also realized that I didn't need external validation for career decisions that felt right to me. I had spent over a year working on constitutional cases that protected fundamental rights and shaped American law. The work was intellectually challenging, morally meaningful, and professionally fulfilling in ways that corporate law could never match. February brought another major case to the court's docket, this one involving educational equity and the constitutional rights of students with disabilities. The case originated in Michigan, where parents had challenged a school district's decision to deny specialized educational services to children with learning disabilities, arguing that the denial violated both federal disability rights laws and the Equal Protection Clause. Justice Rodriguez assigned me to research the constitutional issues involved, working with disability rights advocates and educational policy experts to understand both the legal precedents and the practical impact of various policy approaches. The research was complex and emotionally engaging, requiring me to analyze decades of disability rights law while also considering the educational and psychological needs of children with learning differences. During our initial research meeting, Justice Rodriguez explained her approach to the constitutional questions involved. Education may not be a fundamental right under the Constitution, she said, but when states provide public education, they must do so in ways that don't violate equal protection principle. The school district argues that specialized services are expensive and that they have limited resources to serve all students, I said, but can resource limitations justify denying educational opportunities to students based on disability status? Justice Rodriguez asked, and what are the long-term consequences for both individual students and society when we fail to provide appropriate educational support? The research process involved extensive collaboration with disability rights attorneys, special education teachers, and educational psychologists who helped me understand the broader context surrounding the legal question. I interviewed parents who had fought for educational services for their children, teachers who had worked with students with disabilities, and policy researchers who had studied the impact of various educational approaches. One conversation particularly influenced my understanding of the constitutional issues at stake. I spoke with Jennifer Walsh, a mother in Detroit, whose daughter had been denied specialized reading instruction despite being diagnosed with dyslexia. The school kept saying she would eventually catch up, Jennifer explained, but without appropriate support, she fell further and further behind until she started believing she was stupid. How do you think the constitutional questions should be resolved? I asked. Every child deserves an education that meets their needs, she said. When schools deny specialized services to children with disabilities, they're creating a separate and unequal educational system. This research reinforced my understanding of how constitutional law intersected with real human lives and future. The legal questions we were analyzing had direct consequences for thousands of children, whose educational opportunities and long-term prospects depended on how the Supreme Court interpreted equal protection principles. As spring approached, I began thinking more seriously about my future beyond the Supreme Court. Justice Rodriguez had indicated that she would be happy to extend my appointment for a third year, but I also felt ready to apply my constitutional law expertise in other contexts. The National Justice Initiative, the civil rights organization, where I had originally planned to work, reached out to discuss potential positions in their constitutional litigation practice. They were specifically interested in my Supreme Court experience and my expertise in voting rights and immigration. We need attorneys who understand how constitutional arguments work at the Supreme Court level, explained David Park, the organization's litigation director, during our phone conversation. Your experience with Justice Rodriguez would make you incredibly effective in crafting constitutional arguments and Supreme Court briefs. What kinds of cases would I be working on? I asked. Voting rights, immigration, criminal justice reform, reproductive rights, he said. The full range of civil rights issues, with a focus on cases that have potential Supreme Court implications. The conversation was exciting and professionally attractive, offering exactly the kind of constitutional litigation work I had always wanted to pursue. The National Justice Initiative represented the perfect combination of meaningful legal work and practical impact, allowing me to use my Supreme Court experience to advance civil rights protection. When I told my family about the potential opportunity with the National Justice Initiative, their reaction was mixed and predictable. "It's a respected organization," my father said diplomatically, "but the salary will be significantly less than what corporate firms are offering," my mother pointed out. "The salary is adequate," I said, "and the work is exactly what I want to be doing." "Natalie," Caroline said, "you could work at a corporate firm for a few years, build up savings and financial security, and then transition to public interest work later. Why would I delay doing work I love in order to do work I don't want?" "Because financial security gives you options," my mother said. "Public interest work is admirable, but it's also financially limiting." "I don't need unlimited financial options," I said. "I need work that feels meaningful and important." The conversation continued in familiar patterns, with my family expressing concern about my financial future, while I tried to explain that meaningful work was more valuable to me than maximum income. They seemed genuinely unable to understand why I would choose civil rights law over corporate opportunities that offered higher salaries and greater social prestige. That evening, I made a decision that surprised even me. I called the National Justice Initiative and accepted their offer to join their constitutional litigation practice as a senior staff attorney. The position would begin in July, giving me time to finish my work at the Supreme Court and transition to my new role. The decision felt both natural and liberating. I would be returning to the kind of civil rights work I had always planned to pursue, but with Supreme Court experience that would make me a more effective advocate. I would be working on cases that protected fundamental rights and promoted social justice, using constitutional law as a tool for positive social change. When I called Justice Rodriguez to tell her about my decision, her reaction was immediately supportive and encouraging. "The National Justice Initiative does excellent work," she said, "and you'll be an incredible asset to their constitutional litigation practice." "I'm grateful for everything I've learned working with you," I said. "The experience has been mutual," Justice Rodriguez replied. "You've contributed significantly to important constitutional decisions, and I'm confident you'll continue to make valuable contributions to civil rights law." Over the following weeks, as word spread about my decision to join the National Justice Initiative, I received calls and messages from colleagues and mentors who offered congratulations and encouragement. Professor Chen was particularly enthusiastic about my career choice. "You're doing exactly what Justice Rodriguez did," he said, "using Supreme Court experience to become a more effective civil rights advocate." But I also received calls from corporate law firms who made increasingly attractive offers to convince me to reconsider my decision. The offers were financially tempting and professionally flattering, representing the kind of opportunities that most lawyers could only dream about. Thomas Mitchell from Kellerman, Price and Associates, called again with an offer that included a substantial salary increase, immediate partnership consideration, and the opportunity to work on high-profile constitutional cases for corporate clients. "Miss Brooks," he said, "this offer represents financial security that would set you up for life. You could always return to public interest work later." "I appreciate the offer," I said, "but I've already accepted a position with the National Justice Initiative." "Are you sure you wouldn't consider our proposal? The financial benefits are substantial." "I'm sure," I said. "I'm excited about the work I'll be doing at the National Justice Initiative." After declining the corporate offers, I felt more confident than ever in my decision to pursue civil rights law. The financial security offered by corporate firms was appealing, but it couldn't compete with the satisfaction of doing work that aligned with my values and contributed to social justice. My family's reaction to my final decision was disappointment mixed with resignation. They had clearly hoped that my Supreme Court experience would lead me toward more prestigious and lucrative legal work, and my choice to return to public interest law represented a missed opportunity from their perspective. "I just hope you don't regret this decision later," My mother said during one of our final conversations about my career choice. I won't regret it, I said, with confidence I hadn't felt 2 years earlier. Corporate law will always be there if you change your mind, Caroline. I know, I said. But I won't change my mind. As my time at the Supreme Court drew to a close, I reflected on how much I had grown both professionally and personally during my 2 years working with Justice Rodriguez. I had contributed to landmark constitutional decisions that would protect civil rights for generations. I had developed expertise in constitutional law that would make me a more effective advocate throughout my career. And I had gained confidence in my own judgment and values that would guide my future professional choices. Most importantly, I had learned that meaningful work was more valuable than maximum income, that intellectual contribution mattered more than social status, and that professional fulfillment came from aligning my career with my values rather than pursuing opportunities that impressed other people. The Supreme Court experience had validated my commitment to civil rights law rather than changing it. Working with Justice Rodriguez had shown me how constitutional law could be a powerful tool for social justice, when practiced with both intellectual rigor and moral clarity. As I prepared to begin my new position at the National Justice Initiative, I felt excited about the challenges and opportunities ahead. I would be working on cases that protected voting rights, immigration rights, and other fundamental civil liberties. I would be using my Supreme Court experience to craft constitutional arguments that could shape American law for generations. My family might never fully understand or appreciate my career choices, but their understanding was no longer necessary for my professional satisfaction. I had found work that challenged me intellectually, fulfilled me personally, and contributed to causes I cared about deeply. That was success enough for me. My last week at the Supreme Court felt like closing a chapter that had defined not just my career but my understanding of what I was capable of achieving. Justice Rodriguez and I spent our final working session reviewing the constitutional principles we had helped establish over the past 2 years, from voting rights protections to immigration law reforms to educational equity standards. You've contributed to decisions that will shape American law for generations, Justice Rodriguez said as we sat in her chambers on that Friday afternoon in late June. I hope you understand the significance of what you've accomplished here. I understand that I've been incredibly fortunate to learn from you, I said. The fortune was mutual. Your research and constitutional analysis strengthened every opinion we worked on together. The National Justice Initiative is getting an exceptional attorney. That weekend I packed my belongings from my small Capitol Hill apartment and prepared for the move to my new position. The transition felt both natural and momentous, representing a return to the civil rights work I had always planned to pursue, but with knowledge and experience that would make me infinitely more effective. Monday morning brought my first day at the National Justice Initiative's offices in downtown Washington. The building was modest compared to the Supreme Court's marble grandeur, but it carried a different kind of gravitas, the focused energy of people working to protect fundamental rights rather than simply interpret them. David Park introduced me to the Constitutional Litigation Team, a group of attorneys who had collectively argued dozens of cases before federal courts and had won several landmark Supreme Court decisions. They welcomed me with the kind of professional respect that comes from shared commitment to difficult and important work. Natalie's Supreme Court experience gives us insights we've never had before, David explained to the team during our morning meeting. She understands how constitutional arguments are evaluated at the highest level, which will strengthen every brief we file and every case we argue. My first assignment involved a voting rights case from Texas, where state legislators had implemented new registration requirements that effectively disenfranchised thousands of eligible voters in predominantly minority communities. The legal challenges were complex, requiring sophisticated constitutional arguments about equal protection principles and the scope of federal oversight of state electoral process. Drawing on my research experience with Justice Rodriguez, I crafted constitutional arguments that addressed both legal precedent and practical implementation concerns. The brief I drafted was more sophisticated and strategically focused than anything I could have written before my Supreme Court experience, incorporating insights about judicial reasoning that I had gained through direct observation of the court's decision-making process. "This is extraordinary work," David said after reviewing my draft brief. "Your understanding of how constitutional arguments translate into judicial decisions is exactly what our cases need." 3 weeks into my new position, I received a phone call that would change everything. The caller identified herself as a reporter from the Washington Post who was working on a feature story about young attorneys making significant contributions to constitutional law. "We've been following your career trajectory from law school through your Supreme Court work to your current position," she explained. "Several legal scholars have identified you as one of the most promising civil rights attorneys of your generation. I appreciate the interest, but I prefer to let my work speak for itself," I said. "We've already spoken with Justice Rodriguez, who provided an on-the-record interview about your contributions to major constitutional decisions. She described your work as intellectually rigorous and morally grounded, and said you represent the future of civil rights advocacy." The conversation continued for over an hour, with the reporter asking detailed questions about my legal philosophy, career choices, and perspective on contemporary constitutional challenge. Despite my initial reluctance, I found myself articulating ideas about civil rights law and social justice that I had never expressed so clearly before. "One final question," the reporter said. "What would you say to young attorneys who are considering whether to pursue public interest law despite family pressure to choose more lucrative career paths?" "I would say that meaningful work is its own reward," I replied. "Constitutional law gives us tools to protect fundamental rights and promote social justice. If you believe in those goals, financial considerations become secondary." The article was published 2 weeks later on the front page of the Washington Post Sunday edition, with a photograph of me standing in front of the Supreme Court building and a headline that read, "Young Attorney Trades Corporate Gold Rush for Constitutional Justice." The piece detailed my career path from law school through my Supreme Court clerkship to my current position, emphasizing my choice to pursue civil rights law despite more lucrative alternatives. The article quoted Justice Rodriguez extensively about my contributions to landmark constitutional decisions, described my role in several major cases, and positioned me as part of a new generation of attorneys committed to using law as a tool for social change. Legal scholars from Harvard, Yale, and Stanford were quoted praising my constitutional analysis and predicting significant future contributions to civil rights jurisprudence. My phone started ringing within minutes of the article's publication. Colleagues from law school called to congratulate me on the recognition. Professor Chen called to say he had already assigned the article as required reading in his constitutional law course. Rachel Kim called from Atlanta to say the article was being circulated throughout the civil rights community, but the call that mattered most came from my mother at 8 o'clock Sunday morning, less than an hour after the newspaper was delivered to homes across the Washington metropolitan area. "Natalie," she said, her voice carrying an emotion I couldn't immediately identify, "I just read the most incredible article about you in the Washington Post. You saw it already. Your father drove to 3 different newsstands to find copies. The front page, Nat. You're on the front page of the Washington Post." I waited for her to continue, expecting her usual focus on the career benefits of media attention and public recognition. "I had no idea," she said quietly. "I had no idea that the work you've been doing was so important." "What do you mean?" The article explains what those Supreme Court cases actually accomplished: protecting voting rights, defending immigrant families, ensuring educational opportunities for children with disabilities. I didn't understand that constitutional law could change people's lives in such direct way. Her voice was different than I had ever heard it before, lacking the brittle confidence that usually characterized her conversations about my career. She sounded almost vulnerable, like someone discovering that she had fundamentally misunderstood something important. The article quotes Justice Rodriguez, saying that your research strengthened every decision you worked on together. My mother continued. She says you helped shape constitutional law that will protect people's rights for generations. That's what civil rights attorneys do, I said gently. That's what I've always wanted to do. I know that now, she said. but I didn't understand it before. I thought public interest law was about helping individual people with small problems. I didn't realize you were working on cases that affect millions of Americans. We talked for over an hour that morning, the longest substantive conversation about my work that we had ever had. For the first time, my mother asked detailed questions about constitutional law, voting rights enforcement, and the practical impact of Supreme Court decisions. She wanted to understand how gerrymandering affected Democratic representation, how immigration enforcement intersected with constitutional protections, and why educational equity mattered for both individual students and society as a whole. "I owe you an apology," she said near the end of our conversation. "I've been measuring your success by the wrong standards. You don't need to apologize." "Yes, I do. I called your law degree pathetic at your graduation party. I pressured you to pursue corporate opportunities that you didn't want. I treated your commitment to civil rights law like it was a phase you would outgrow. You were trying to look out for my financial security. I was trying to force you into a definition of success that didn't fit who you are or what you care about," she said. "The article makes it clear that you've achieved something much more significant than financial success. You've found work that matters." Caroline called later that afternoon with a similarly transformed perspective on my career choices. She had seen the article and spent the morning researching the Supreme Court cases I had worked on. "I had no idea voting rights law was so complex," she said. "I looked up that gerrymandering case you worked on, and the legal analysis is incredibly sophisticated. Constitutional law is more complex than most people realize." The article mentions that corporate law firms have been trying to recruit you with substantial salary offers. "I'm sorry I pressured you to consider those opportunities. You were trying to help. I was applying business logic to professional choices that aren't primarily about business," Caroline said. "I understand now that some careers are about impact rather than income." That evening, my father called with his own reflections on the article and what it had taught him about my work. "I've been reading about the National Justice Initiative," he said. "They've won some incredibly important cases over the years. They do excellent work." The article mentions that Justice Rodriguez chose you specifically because of your commitment to civil rights law, not despite it. Your values were what made you attractive to her, not something you needed to compromise. "That's right. I'm proud of you," he said not because of the recognition or the prestigious position, but because you've found work that aligns with your principles and makes a difference in the world. Over the following weeks, the Washington Post article generated additional media attention and professional opportunity. Legal journals invited me to write articles about constitutional interpretation and Supreme Court decision-making processes. Law schools asked me to guest lecture about civil rights advocacy. Civil rights organizations reached out about potential collaborations and consulting opportunities, but the response that meant the most came from people whose lives had been affected by the constitutional decisions I had helped research and craft. Letters arrived at the National Justice Initiative from voters whose rights had been protected by the gerrymandering decision, from immigrant families who had been helped by the humanitarian assistance ruling, and from parents of children with disabilities who had benefited from educational equity protections. One letter particularly moved me. It came from Maria Santos, the teacher I had interviewed during my research on the immigrant education case. "Dear Miss Brooks," she wrote, "I wanted you to know that the Supreme Court's decision in the education case has already changed things for my students. The school district can no longer deny enrollment to undocumented children, and several families who had been hiding are now sending their kids to school. Thank you for helping to protect these children's rights." These letters reminded me why I had chosen civil rights law in the first place. Constitutional decisions weren't abstract legal exercises, but had real consequences for real people. The work I was doing at the National Justice Initiative was helping to protect fundamental rights and promote social justice in ways that would benefit countless Americans for generations. 6 months into my position at the National Justice Initiative, I was assigned to lead the organization's amicus brief in a major Supreme Court case involving criminal justice reform. The case challenged mandatory minimum sentencing, laws that disproportionately affected communities of color, raising constitutional questions about equal protection and the Eighth Amendment's prohibition on cruel and unusual punishment. The assignment represented both a professional honor and a personal milestone. I would be arguing constitutional principles before the same court where I had worked, drawing on insights I had gained through direct experience with Supreme Court decision-making process. Preparing the brief required months of intensive research and strategic analysis, working with criminal justice experts, constitutional scholars, and community organizations to craft arguments that addressed both legal precedent and social policy consideration. The work was intellectually demanding but deeply satisfying, representing exactly the kind of constitutional advocacy I had always wanted to pursue. When the brief was filed, it received significant attention from legal scholars and media commentators who praised its sophisticated constitutional analysis and compelling policy arguments. Several law professors assigned it as required reading in their criminal justice courses, and civil rights organizations circulated it as an example of effective Supreme Court advocacy. The Supreme Court accepted the case for oral argument, scheduling the proceedings for March. I would be attending the arguments not as a court employee but as an advocate, watching Justice Rodriguez and her colleagues evaluate constitutional arguments I had helped craft. The night before the oral arguments, I called my family to tell them about the significance of the case and my role in preparing the constitutional brief. "You're arguing before the Supreme Court," my mother asked. "Not arguing personally, but I wrote the brief that our co-counsel will be presenting." "That's incredible, Natalie. Are you nervous?" "Excited more than nervous. This case could establish important protections against discriminatory sentencing practices." "I'll be thinking about you tomorrow," she said, "and about all the people who will be helped if you win." Her comment reflected the transformed way she now understood my work. Instead of focusing on the professional prestige of Supreme Court advocacy, she was thinking about the human impact of constitutional decisions. The oral arguments were compelling and contentious, with attorneys on both sides presenting sophisticated constitutional theories about the scope of equal protection guarantees and the appropriate role of federal courts in criminal justice reform. Justice Rodriguez asked several penetrating questions that revealed her deep engagement with the constitutional issues involved. 3 months later, the Supreme Court issued its decision, with Justice Rodriguez writing a majority opinion that adopted many of the constitutional arguments from our amicus brief. The decision established new protections against discriminatory sentencing, while providing practical guidance for federal courts reviewing criminal justice practices. Legal scholars immediately recognized the decision as a landmark ruling that would strengthen constitutional protections for generations. Civil rights organizations praised the ruling as a significant victory for criminal justice reform and equal protection principles. When I called my family to tell them about the Supreme Court victory, their responses reflected their evolved understanding of constitutional law and civil rights advocacy. "You helped write the arguments that convinced the Supreme Court," my mother said. "That's extraordinary, Natalie." It was a team effort, but yes, our constitutional analysis influenced the court's reasoning. "I'm so proud of you," she said, "not just because you won, but because you're fighting for people who need constitutional protection." A year after the Washington Post article was published, I received an invitation that represented the culmination of everything I had worked toward since law school. The American Constitution Society asked me to deliver the keynote address at their annual conference, speaking about the future of civil rights advocacy and constitutional interpretation. The invitation was both professionally significant and personally meaningful, representing recognition from the broader legal community that I had established myself as a credible voice in constitutional scholarship. The speech would be attended by hundreds of attorneys, law professors, and legal advocates who were working to protect civil rights and promote social justice. I spent weeks preparing the address, crafting arguments about the role of constitutional law in protecting fundamental rights and the importance of ensuring that legal advocacy remained connected to the communities and causes it was meant to serve. The speech was well received, generating extensive discussion about constitutional theory and civil rights strategy, legal journals published excerpts from the address, and several law schools invited me to expand the arguments into academic articles, but the response that mattered most came from my family, who had watched the speech online and called immediately afterward to share their reactions. "That was incredible," Caroline said. "You made constitutional law accessible and compelling in ways I never understood before." "You found your calling," my father added. "It's clear that this is exactly the work you were meant to do." "I'm sorry it took me so long to understand," my mother said, "but I'm incredibly proud of the attorney and the person you've become." As I reflected on the journey from that humiliating graduation party to this moment of professional recognition and family reconciliation, I realized that my mother's initial criticism had been wrong in every possible way. My law degree wasn't pathetic, and my commitment to civil rights law wasn't a waste of my talents or education. I had found work that challenged me intellectually, fulfilled me personally, and contributed to causes that mattered deeply to me. I had helped shape constitutional law in ways that protected fundamental rights and promoted social justice. I had built a career that aligned with my values and utilized my abilities in service of something larger than myself. The recognition from Justice Rodriguez, the media attention, and the professional opportunities were gratifying, but they weren't what made my work meaningful. The meaning came from knowing that constitutional decisions I had helped research and craft were protecting voting rights, defending immigrant families, ensuring educational opportunities, and reforming criminal justice practices. My family's evolved understanding and support was deeply satisfying, but it wasn't necessary for my professional fulfillment. I had learned to value my own judgment and trust my own priorities, regardless of whether other people understood or approved of my choices. Looking ahead, I could see years of challenging and important work at the National Justice Initiative, opportunities to argue additional cases before the Supreme Court, possibilities for teaching and scholarship that would help train the next generation of civil rights attorneys. Most important, I could see a future where constitutional law continued to serve as a tool for social justice, where legal advocacy protected the most vulnerable members of society, and where young attorneys would choose meaningful work over maximum income, because they understood that some rewards couldn't be measured in dollars. That evening, I called Aunt Helen to share the news about the keynote speech and to thank her for the support she had provided throughout my journey. "You've become exactly who I always knew you could be," she said. "Thank you for believing in me when other people didn't." "I didn't believe in you," Helen said. "I believed in the work you wanted to do. I knew that if you found work you loved, you'd find a way to excel at it." As I hung up the phone and looked around my small apartment, filled with constitutional law books and case files, I felt a deep sense of satisfaction and purpose. I had built a career that mattered, found work that challenged and fulfilled me, and contributed to constitutional protections that would benefit countless Americans for generations. My mother had been wrong about everything that night at the graduation party. My law degree wasn't pathetic, and my commitment to civil rights law wasn't a limitation but a strength. Justice Rodriguez had recognized that strength, and given me opportunities to develop it into expertise that now served both the legal profession and the broader cause of social justice. Some victories aren't measured in salary figures or social status, but in lives changed, rights protected, and justice advanced. Those were the victories that mattered most to me, and they were victories I would continue pursuing for the rest of my career. Up next, you've got 2 more standout stories right on your screen. If this one hit the mark, you won't want to pass these up. Just click and check them out.